Hello friends, welcome to Bankers Plus Academy. Sarfaesi Act or Income Tax Act, which has supremacy over the other. The Madras High Court has recently held that attachment orders passed by the recovery officer or income tax department after creation of mortgage in favor of a secured creditor do not serve any useful purpose. In other words, the court has held that Sarfaesi Act has supremacy over Income Tax Act in respect of attachment of assets for recovery of dues. The same is the case with RDB Act or Recovery of Dues Due to Banks and Financial Institutions Act, which is also an important act widely used by banks for recovery of their dues in stressed accounts. The court has decided on priority of charge under Income Tax Act vis-a-vis the Sarfaesi Act and RDB Act while considering a set of writ petitions filed by and against the Income Tax Department in cases where the properties mortgaged to certain banks and non-banking financial institutions were sought to be attached by the Income Tax Department. The contention of the IT department was that Section 281 of the IT Act declares any transfer made by the assessees during the pendency of proceedings under the Act as void. Therefore, the attachment of the immovable property made by the tax recovery officer to secure the dues of the department was legal, lawful, and not perverse. This was their argument, but this argument was strongly challenged by the financial institutions. They pointed out that Section 26E of the Sarfaesi Act provides that debts due to any secured creditor shall be paid in priority over all other debts and revenues, taxes, cesses, and other rates payable to the central government, state government, or local authority. The financial institutions also quoted the decision of the Andhra Pradesh High Court in ICICI Bank Limited versus Tax Recovery Officer and others 2019, wherein it was held that the Income Tax Act does not provide for any primacy to income tax dues over that of the government dues, and priority of crown debts is only over unsecured debts. They also quoted an earlier judgment by the full bench of Madras High Court in Assistant Commissioner of Commercial Tax and others versus Indian Overseas Bank and others 2016. In this case, it was held that in view of Section 31B of the Recovery of Debts and Bankruptcy Act, introduced by the Enforcement of Security Interest and Recovery of Debts Laws and Miscellaneous Provisions Amendment Act 2016, the right of the secured creditors to realize the debts by way of sale of assets will have priority over all debts and government dues, including revenues, taxes, cesses, and rates due to the central government, state government, or local authority. The court observed that orders of attachment passed by the tax recovery officer or income tax department in the above cases, where writ petitions were taken up, were subsequent to the mortgage created in favor of the secured creditors, and hence the same will have no legs to stand in view of the facts, acts, and judgments taken into consideration by the court. This judgment should bring a lot of relief for bankers, since there are many instances where the bankers have found themselves intimidated by IT attachment orders on properties which were mortgaged to the banks for their stressed assets. It is the general belief that IT attachment orders are issued for sovereign dues, and as such they hold priority over any claims by banks. But the court has clearly stated that IT attachment orders cannot be treated above the claims of secured creditors, as it is clarified beyond doubt that priority of crown debts is only over unsecured debts.